Oh, no, thank you, Your Honor.
I got a whole pharmacy up here if you need it.
You were much more prepared for today than I was. Excuse me. Courtney Hoare, on behalf of the state, may it please the court, I would like to reserve 5 minutes for rebuttal with the court's permission.
Certainly.
We are here today on the grant of state habeas corpus relief in the defendant's robbery, I believe it's robbery conviction, where the court found that the defendant's sentence, 6-year probationary sentence, had expired. Just to give this court a very brief overview of this sentence, the defendant pled guilty and received an agreed-upon 6-year sentence that was set to be served consecutively to a prior unexpired portion of his 8-year sentence. From the evidence we have in the record, it appears that he began serving his 6-year sentence based on TDOC records sometime in 2015, November 2015. He was released on parole for the 8-year sentence in 2015. But since he began serving his sentence for the 6-year sentence, he violated parole several times, or violated probation several times, excuse me. For each of those probation violations, the court awarded jail credit for the amount of time that he was incarcerated pending the violation of probation hearing, and the judgment of conviction shows several days, or I think a couple hundred days of jail credit. In total, when you calculate up all the jail credits from those probation violations and his pre-plea incarceration, it comes to 488 days, I believe. It is nowhere near the 2,188 days that the court found.
So how did the trial court get there then?
It is not clear.
Well, that raises kind of an interesting issue. Yeah. I mean, you suggest in your reply brief, no, you don't suggest, you state outright in the reply brief that the proper parties were not before the habeas court. And if it's not clear from the record how the habeas court reached its determination that the sentence had expired day for day, I suppose in the habeas context, would it be proper to remand the case for a hearing with findings with the proper parties before the court? I mean, the state hasn't had the opportunity to make any of these arguments below. My recollection of the record is that the state offered no argument on the habeas petition below by way of the district attorney's office, so your office hasn't had the opportunity to be seen or be heard.
We have not. And regarding the state saying it has no argument, there's an interesting wrinkle in that part of the record as well. By that point, the court's order had already come down.
Sure.
The court's order was released in early November of 2024. That, I believe it was a chambers, may have been a hearing of some sort, occurred in late November of 2024.
Looked like it was issued sua sponte to me.
Yes.
And then,
well, the defendant had, it was not truly sua sponte, the defendant had filed a Rule 36.1/post-conviction, is how it's styled. The court in its order said it was construing that as a habeas petition and found through its own calculations that he had served 2,188 days on one, I think that's without the parole credits, and then more with the parole credits. And based on my calculations, I can get to about 2.25 years of jail credits based on what's in the record, but the rest of it, the court does not explain where those additional days came from. It's possible that at one point after his final probation violation, the defendant was ordered to serve the remainder of his sentence. But there's conflicting evidence in the record about how...
In fact, that would have to be the case, right, to get to the trial court's number.
It would have to be, but the record does not clearly show that that is exactly what happened. It shows that those are the day-for-day time that he served.
Sure.
There's some, and I know my friend on the other side has taken issue with us citing some of the TDOC records, but that is not to say definitively that the defendant was not incarcerated in that time. Instead, it shows that this record is conflicting on how much time the defendant was incarcerated after his final probation violation, which goes to show that the record is not clear regarding whether the sentence has expired, and habeas corpus relief is not appropriate here. Now, to answer your Honor's questions about remand, certainly if this court wants to remand, we will file a response and make the appropriate arguments. I think, though, looking at the record here, this court can reverse and just reverse the trial court's order and say that this is not appropriate for habeas because the record does not show that the sentence has expired here. If the defendant wants to file another habeas petition with the proper documentation, with the proper procedural requirements, and present some more documentation to show where those additional days can come, he is more than willing or more than able to do so. But he did not do that.
I think one of the issues that maybe as I was reviewing the record here is that, I mean, the DA's office perhaps admittedly, maybe not the proper party below, didn't raise any of these issues. And so the trial court was, in maybe sua sponte granting habeas relief, wasn't on notice that there needed to be additional proof in the record. The state wasn't raising a challenge to it. The petitioner apparently was fine with the order as it was. And I think for us to be making a ruling here on the record, I think the court would benefit, frankly, by having the proper parties before the court so that these issues can be heavily considered.
And that is certainly a remedy that is available to this court. I would submit, though, that in addition to the lack of clarity regarding the expiration of the sentence, this court can also reverse grant of the habeas corpus relief based on the procedural grounds. And I know the defendant has argued that we have waived our challenge of the procedural grounds because we didn't raise those below, but as Your Honor has noted, it was not the proper parties before this court.
Let me ask that. I mean,
Yeah.
could the trial court, does the trial court have statutory authority to grant habeas relief sua sponte?
It has statutory authority to grant the relief, but it does not have statutory authority to construe a non-compliant petition as a habeas petition.
Okay, what about this? Well, and maybe sua sponte and help me with this. Did the statutes permit the trial court to grant habeas relief in the absence of an application?
Section 2921-104 does.
Well, 107 does too, right? Or 104, where it says that the court is authorized to grant the writ when it has evidence from a judicial proceeding. I suppose that a Rule 36.1 motion and its consideration would be a judicial proceeding. The court has authority to grant the writ, although no application be made therefore. The procedural requirements applied, do they not, only when an application is filed? And so when there is no application and the trial court is acting pursuant to statutory authority to grant habeas relief on its own, it seems incongruous for us to then come back and require that the petitioner comply with procedural requirements that the petitioner was never on notice about. So for example, in this case, petitioner was never, he filed a post-conviction motion, a 36.1 motion, didn't file a habeas motion, didn't seek habeas relief, was not on notice that he needed to comply with the habeas statutes. But the trial court, acting under its statutory authority, was authorized to grant it. Whether that was proper or not is a different issue, but was authorized to grant it procedurally. But now the state is arguing that because the petitioner failed to comply with the habeas procedural requirements, that his petition should be dismissed.
I think if what we were talking about is that this case was before the court purely on a Rule 36.1 matter, and that's what we're arguing, and the court said, I'm denying the Rule 36.1, but I see that from the clarity of the record that this sentence has expired, so therefore I am granting habeas corpus relief, then that would be the situation in which Your Honor's hypothetical and 104 would apply.
Okay, that's not this case?
That's not this case.
Okay, why not?
So here, what we have is a Rule 36.1 post-conviction motion, and then, as I've already said, it is not, I want to back up one step first. 104 requires two things. It requires the case to be before the court's jurisdiction by some sort of mechanism. And I would agree that a Rule 36.1 motion or a post-conviction petition would satisfy that. But for sua sponte relief to be granted, it has to be clear from the record of those proceedings and from the record of the proceedings below, or excuse me, I believe the language for habeas is the judgment and the record upon which the judgment is based, that the sentence has expired. We do not have that here. And so Rule 104, or excuse me, Section 104 would not allow the court to grant that sua sponte relief. And in no circumstance would Section 104 allow a court to take a non-compliant motion and construe it as a habeas petition as it did here. Because the Section 104, under its plain language, says that relief can be granted even if there is no application. It does not allow a court to take a non-compliant motion and construe it as a proper habeas application.
I don't think the trial judge here, or the habeas judge here, construed it as a proper application. I think the habeas judge recognized that the sentence had been expired, and that as a result of that, the petitioner was being illegally held, which is a ground for issuance of the writ of habeas corpus.
My memory of the order is saying I am, at the beginning of the order says, I construe this as a habeas corpus claim. And the state's position would be that construing a non-compliant motion as a habeas corpus petition is different from the 104 sua sponte grant of habeas corpus relief based on apparent and obvious evidence in the record that habeas corpus relief is appropriate.
Let me ask just briefly here. You've said it a couple of times now that the expiration of the sentence has to be clear from the record. In other cases where the trial court lacks jurisdiction, that has to be clear from the record. Archer says that, Ritchie says that, every case says that. How would you ever show that a sentence has expired? How would you ever show that from the record?
I think in this case,
all of that is post-record. All of that is post-proceedings in the trial court. So if you take me into custody on a 10-year sentence, but I'm being held for 20 years, my underlying record is not going to show that I'm being held for 20 years, but I am being detained illegally.
I think there are any number of ways that the petitioner would be able to show an expired sentence. Here, we can agree that the jail credits that have been accrued through the post-judgment litigation of this case shows at least 2 years of jail credit that has been served towards the sentence. And then
the TDOC time is the TDOC time outside of the record?
There are some TDOC records in this record. I think if a defendant truly were to say, my sentence has expired, and attaches an affidavit about the TDOC's calculation of his sentence to a properly filed habeas corpus petition, any other sworn...
Would Thomas records be sufficient, or would that be an improper consideration of a...
I believe it would have to be a sworn affidavit or declaration of some type, instead Thomas record probably would not be sufficient. But, you know, I know generally speaking, we don't have hearings to present proof at habeas corpus petitions or habeas corpus proceedings, but that does not stop a defendant from attaching proof and additional declarations or factual evidence to his petition. And here, because this court improperly construed a Rule 36.1 motion as a non-compliant habeas petition, we simply have none of that information. And there's nothing in the record that I can find that supports the trial court's calculations showing several thousand days of jail credit that show that the sentence has expired.
One more question, then I'll stop, I promise. In the post-conviction context, for example, a pro se petitioner files, let's say, a procedurally improper petition for post-conviction relief. Maybe it's not sworn, maybe it's not signed, something like that. And I think the Supreme Court has held that for a post-conviction pro se petitioner, that the trial court must offer an opportunity for amendment before it's dismissed for failure to comply with the procedural requirements. I don't see anything in the habeas statutes that requires that or even authorizes that. So if the habeas judge here had a Rule 36.1 motion, looked at its attachments, concluded the sentence had expired, is it the state's position that the habeas judge could not have treated that as a habeas motion sua sponte under 104, dispensed with the procedural requirements, and then granted relief on his own?
I want to make sure I understand Your Honor's hypothetical. It's that we have a Rule 36.1 motion with accompanying documentation to show an actual expired sentence.
Right.
I believe that would fall under Rule 104, or excuse me, Section 104, where it is properly before the court on a procedural ground that's not habeas corpus, and the record shows clearly that the sentence has expired. In that case, the courts, it would not be construing it as a habeas corpus petition, but instead would say, I sua sponte grant habeas relief based on the evidence before me.
Okay.
But that's not what we have here.
Wasn't the trial court correct, though, when they determined that 36.1 wasn't a proper vehicle to consider the application of pretrial jail credits and post-conviction jail credits? That's why he looked at it and said, yeah, 36.1 is not the proper way, but I can look at it as a habe. So what my concern is we're looking at 104 and saying, all right, once you get within the jurisdiction of the court, then the trial court has an obligation if it's expired. my question is, was the defendant properly before the jurisdiction of the court because he filed a 36.1, which doesn't get you before the court properly to consider pretrial jail credit. The way to get before the court now is to file a proper petition for writ of habeas corpus, which he didn't do and didn't comply with. You understand what I'm?
Yes, I understand what Your Honor is saying. I would hesitate to say that a Rule 36.1, because the language of his Rule 36.1 motion says this sentence is illegal, which is a proper Rule 36.1 claim. Now, his basis for that is not real. It says, I feel the sentence has expired. And that's the quote, is I feel.
I thought he, you know better than I do. I thought he had put in there that there was unawarded jail credit that would make it expired. I thought maybe.
I don't think it was jail credit. I think it was the TDOC's calculation of good time credit, which would be an Administrative Procedure Act claim.
Right.
It would not be a Rule 36.1 claim, but I hesitate to say that that would completely take it out of the court's jurisdiction because it's still a Rule 36.1 motion filed, and the court would not so much dismiss it, but they could say they deny there's jurisdiction to deny the motion based on a non-cognizable Rule 36.1 claim. And that is what I believe kind of the Supreme Court's and this court's examinations of jurisdiction in the Abdurrahman case, in the Purvis Payne case, is that there has to be an authority that gets something before the court's jurisdiction. Now, whether it's meritorious or not is a separate question.
But then, doesn't that, I'm sorry, I know your time's up.
You're good.
You're fine, Judge.
Doesn't that completely undercut the 107 of the Hague? Like, if you can just file anything and get yourself before the jurisdiction of the court and hope the court makes a 104 finding, then why ever comply with 107? Why don't you just file a 36.1, whether or not it's proper or not, and then just say, hey, Judge, I think it's expired.
And I think that's where the state's position that 104 has to be incredibly limited in when it can be invoked, is that it has to be something probably before the court, and it has to be apparent, clearly apparent on the record that a sentence has expired is the only time in which habeas corpus, sua sponte habeas corpus relief is appropriate. And also the limiting principle that 104 cannot be used to excuse the requirements of 107.
Okay, thank you.
All right, General, thank you very much.
Unless this court has further questions, I will reserve whatever remaining time I have left for rebuttal.
Thank you. You'll have your time. Mr. Ridley, good afternoon to you.
Good afternoon, Your Honors. Todd Ridley on behalf of the appellee, Maurice Flanigan. So I guess I'll start. It seems like we've kind of gone through the procedural history of this case, so I'll just kind of get right into the argument. The state has waived its appellate argument in this case because it affirmatively acquiesced to what happened in the trial court below.
Do you agree that the AG's office should represent the state in a habeas proceeding in a habeas court?
I agree that the AG's office typically does represent the state in habeas corpus proceedings.
It has exclusive statutory authority, doesn't it, in a civil case to represent the state?
I'm not sure it has exclusive statutory authority to. It is statutorily obliged to do it, but I don't think that another state attorney is like prohibited from representing the state in that proceeding.
And I'm not saying that it does or that it will, if the court disagrees with that proposition that the local district attorney can represent the state in a habeas case, you would have a case here where the proper parties are not before the court then. At that point, has the state really waived anything?
If the court is finding that the Attorney General's office has to be there, then I suppose I agree.
Okay.
That remedy is the correct one.
Okay.
Where I disagree, though, is that the Attorney General's office itself has to be there for this court to be able to do anything else. So I think what the statute says, the statute just says that the Attorney General's office represents the state in all civil matters. The state has not cited to anything, because I don't think there's anything that exists, that says in a habeas corpus case, because the Attorney General's office represents the state in civil matters, that because the AG does that, then in habeas corpus matters, all of a sudden everything must go to them automatically and that no one else can step in. Because the party here is not the Attorney General's office. The party before the court is the state of Tennessee. And an attorney representing the state of Tennessee was in the court, and that was from the district attorney's office.
What statutory authority do district attorneys have to represent the state in civil cases?
I'm not sure the DA has statutory authority to represent the state in civil cases, but the DA does have the authority to represent the state. If the DA felt, well, or I do not have the authority to represent the state in this context, they can pick up the phone and call the Attorney General's office. They can send an email to the Attorney General's office and say, hey, I'm here as the state's attorney right now, but I don't think it should be me. I think it should be the AG's office. From the trial court's perspective, or from the defendant's perspective, or any other litigant's perspective, they're dealing with the state because there's an attorney from the state there. And from their perspective, what else are they going to rely on? So what the statute's doing when it says the Attorney General's office is responsible for handling civil litigation is essentially just saying, well, we're going to fund the Attorney General's office X number of dollars, and for that funding, they need to handle these types of cases. DA's offices, on the other hand, we're going to fund you this way, and you handle those types of cases. But because of that, that doesn't mean that the DA's office is precluded from representing the state when they're in the trial court already representing the state. Because from the trial court's perspective, what they have is an attorney from the state of Tennessee saying, I'm here for the state, here's the state's position, or in this case, not taking a position. And I'm not sure what else a trial court is supposed to do under those circumstances.
Haven't we not already resolved this issue in Pirtle? Can't remember the year, 2009 case maybe?
2009 is an unreported case from this court where
it's unreported, but it is a case holding that the AG is the proper party in a habeas case.
I don't think that's what the court held in that case. So what happened in that case is that a defendant filed a habeas corpus petition. The Attorney General's office came in and represented the state in the trial court in that petition, as it typically does. The defendant objected to the Attorney General's office being present at that hearing, saying the Attorney General's office can't represent the state in a habeas corpus petition. And what the court said is, yes, it can. Here are these statutes. But it does not say, or it does not go so far as to say, well, because the Attorney General's office does represent the state in these proceedings, then no other state attorney could possibly represent the state in this way.
Okay, so back to Judge Hickson's question then. What statutory authority is there for a local elected district attorney general to represent the state in a habeas case?
I don't know if there is a statutory authority that says the DA's office can represent the state in this context.
There would have to be, right? Because there are statutes recognizing the authority of the district attorney general in various places. So your local elected DAs act pursuant to statute. They act pursuant to authorities granted by statutes.
I certainly understand that the DA is not explicitly authorized to handle habeas corpus matters by its statute. It is typically going to just be prosecuting cases, defending post-convictions, the other things that are typically.
So if the DA doesn't have statutory authority to represent the state in a habeas case, and the Attorney General's office has authority to represent the state in a habeas case, isn't the Attorney General the only authorized party pursuant to statute to represent the state in a habeas case?
I think that would be an administrative dispute between the Attorney General's office and the DA's office, and maybe something that the legislature would need to get involved in to clarify like which state agency really needs to be involved here. But from the point of view of the court system, what they have is Maurice Flanigan v. State of Tennessee. And Maurice Flanigan's pro se, in the trial court at least, and the State of Tennessee appears to be represented by the DA. And the DA knows its limitations, and if it believed it had limitations, it could have, again, called the Attorney General's office and said, hey, y'all need to handle this and not us.
Mr. Ridley, let me ask you about where in the record it shows that this DA's office actually did handle this. The trial court's order said the court gathers that the state does not dispute the expiration of the sentence, but as I looked at it, it looked like they came in, the judge brought him in because he thought his sentence was probably expired, but he wanted the DA's office to have an opportunity to look at it. He was going to move it over to the next week. The defendant complained, wait, you said you granted my order. Why am I not getting out? And so the judge, being the kind person that he is, said, well, let me look for the specific ADA. And they go to lunch, and then when they come back, the record that I saw that I remembered, there was nobody from the DA's office saying, we agree with that. I didn't see anything in the record where the DA's office said what the trial court's order said.
Okay, so I agree that the transcript that we do have, it's pretty scattered. It looks like it starts off in the morning, then there's a break, and then it comes back, and then there's another break. I think it's possible that what happened is that some of this is maybe off the record, or maybe not in chambers, but out in the hall between a DA who's doesn't appear to be that invested in this issue. And at this stage, frankly, the defendant does not have representation either. So I get the distinct impression that a lot of the reason we don't have much in the record about this is because the state didn't step up and say anything. And it appears that the state's acquiescence to what the trial court did is what caused all of these issues or the lack of clarity in the record. Because had the state at any point said, we have a problem with any of this, or honestly, if the state had at some point said, we need the Attorney General's office to be involved in this, then the court could have conducted the kind of granular detail analysis of which parts of the sentence had been served and not. But because the state didn't get up and say anything, the trial court never really got to test or had the opportunity to test kind of its calculations versus what the state felt. So I guess turning back to like what happened in the trial court, the thing that is clear to me from what the trial judge said in the transcript and what's in its final order is that the state at no point told the trial court, we have a problem with this. And so that leads to the language in the final order saying, the court takes it that the state does not object to this. And I have nothing else to go on. And this court has nothing else to go on. Because if the state had wanted to lodge an objection, they had plenty of time to do it. Plenty of places where they could have done it. At any point, the DA could have at that hearing just stood up and said, Your Honor, we need a week. But he didn't do that. The only thing we have from that transcript, though, is we have the presence of the DA. We have the trial judge saying, I need to make sure the DA can respond to this. And then we have the trial judge coming back after a break and saying, looks like the DA doesn't have a position or is not objecting to this. And so from the trial judge's perspective and from what this court has in the record, the trial judge has his calculations saying, it looks like this gentleman has served his sentence. I've asked the state if they want to take a position, and they apparently have told me no. They don't have any interest in doing that. So from his perspective, what else is there to do at that point except grant the petition? And the state, what it does in response is absolutely nothing. It doesn't go back to the trial judge and say, hey, we don't think you had the authority to do this. We don't think your calculations are quite right. No, instead what they do is they file a notice of appeal to this court. They file a motion to stay in this court that does not articulate any grounds for stay. They actually take Mr. Flanigan back to prison and hold him there until this court rules on the motion to stay. And ultimately, what the state does is they wait until the principal brief in this case, so approximately 9 months after the trial court had this issue, before they say there was any problem at all here. And so I guess I just come back to, I agree with Your Honor's point about what is in the record, about what the state did and did not do, but the state's silence is telling. Because if the state at any point wanted to articulate any of these things, they were more than capable of doing so. And the trial court took pains to give them the opportunity to do so, but they simply chose not to.
Mr. Ridley, do you think the trial court, or I should say the state, has a right to be heard at all if the trial court's granting sua sponte relief under 104?
I do not think I would characterize this as sua sponte relief. The trial court's getting a petition motion from a pro se defendant. He's reviewing it and then making findings based off of it, then giving the state an opportunity to respond. And so I guess I'm not sure what else the trial court's obligation is at that point. They've got a petition, they're considering it, the other side has an opportunity to respond, and he's putting down a ruling. And
well, you see, we keep getting back to this thing. If you have the wrong attorney there representing the state, you're putting a lot of stock in what that attorney has to say on behalf of a party that it's not legally authorized to represent. You see what I'm saying there? Like if someone walked in here other than you and said, I represent Mr. Flanigan in this case, would it be right for this court to rely upon their representations when they were not, in fact, Mr. Flanigan's attorney?
that would I agree with that. I think there is a big difference between an attorney for the state of Tennessee actively representing the state in a criminal matter in front of the court, and then another case comes along where the state of Tennessee is also a party. And again, this comes back to like the statutory distinctions between the DA's role and the AG's role is very important for funding.
Well, it's not just that. State lawyers are not fungible.
They are not fungible.
So someone who represents the local elected district attorney has defined powers pursuant to a statute. Someone who represents the Department of Children's Services has defined powers. Doesn't mean that someone from the Department of Children's Services can come into the criminal court on a habeas petition just because they represent the state.
I completely agree
Well,
with
good.
that.
I mean,
but
what I'm saying is that I thought we had established that the AG has statutory authority, that
Yes.
the local district attorney doesn't have statutory authority. And so once we concede those 2 points, I think the only proper party before the court in a habeas case must be the Attorney General.
Which is why I'm asking, if I can piggyback this question, does the state have to be notified at all if the trial court is granting a sua sponte relief? I know you're saying this isn't, but it doesn't meet the procedural requirements. You had the wrong state's attorney, not you, but they had the wrong state's attorney in the trial court when it happened. Does the trial court just have the authority to grant writs without notifying the state under that statute?
I think the state had more than enough notice here. So when the court says that state attorneys aren't fungible, I agree, particularly when you're talking about, say, DCS versus a DA's office. Those are completely different entities. But the Attorney General's office and the DA's office are fairly intermeshed, where the DA's office and the AG's office are going to be, or should be, communicating in fairly big detail about the state's position in criminal cases.
Let me give you maybe an obvious example that may draw the distinction a little further. The local district attorney could not step foot into United States District Court and represent the state of Tennessee on a federal habeas petition. Only the Attorney General can do that. There's no authority for the state to.
I'm actually not sure the state can represent in a
You think the district attorney general may be able to represent the state of Tennessee in a federal habeas case?
I think it depends on who is the party in that case. So if you're suing like a local sheriff, it would probably be the local county
Oh,
attorney.
Mr. Ridley, are you aware of any authority that would allow a district attorney to step into the United States District Court on a federal habeas case?
A district attorney, no, but other state attorneys outside of the Attorney General's office might.
Okay, well, I think that draws into clarity. I think maybe the principle we're talking about here is that the DA can only act when the DA has authority to act. And I think we've all conceded the DA doesn't have authority here specifically, or even generally, to act in a state habeas case, but the Attorney General does. And so the Attorney General seems to be the proper party. I mean, I think I would ask you, your friend on the other side, why isn't the remedy here just a remand for a new hearing with the proper parties?
I am not opposed to a remand for that purpose, because I think there is fundamentally the bigger problem in this case is actually doing the calculations. Some of what you can see, I think, from the state's brief, where it's trying to do these calculations based off printouts that aren't that legible, that maybe this would benefit from everybody going back and figuring out, like, okay, how much time did he actually serve? And let's figure all that out together. And maybe if the Attorney General's office is there or somebody from TDOC who can help with the calculations, that would be beneficial for the trial judge, it would be beneficial for Mr. Flanigan, and certainly for the trial court. So if the court's interested in doing that, we're not opposed to going back and having the trial judge kind of show its math again. But the state, again, had the opportunity to do this. So this notion that the state's attorney is somehow incapable of like going forward on a habeas proceeding just does not, in my mind, give the state's attorneys enough credit, where, again, they're more than capable of saying, okay, we're here today on an unusual case. Judge, before you do anything, let me pick up the phone.
Sure, it's not a question of capability. I know that this assistant district attorney, perfectly capable of raising objections, does so all the time. Good district attorney general, in my view. It's a question of authority. It's not a question of capability, it's a question of authority. And so whether this particular district attorney picked up the phone or not, I think it seems like we're all agreed that he doesn't have the statutory authority to represent the state in this case. And so If that's the case, I wonder if we just need to have the proper parties before the court.
So parties before the court would just mean going back into the trial court with the Attorney General's office now present to help do this calculation?
And the Attorney General's office now present to be able to make the objections that the Attorney General is now making back before the habeas court. And that is, this petitioner hasn't complied at all with the procedural requirements here. Judge, you don't have authority to issue this sua sponte under 104 because the Rule 36.1 motion without the attachments is not evidence from a judicial proceeding. And so that way then the court can consider under 104 the scope of its own authority with the proper parties before the court making the proper objections.
In that case, we would just ask that Mr. Flanigan also be permitted to have counsel and be able to go back and articulate his own position about how his sentence was calculated in the first place. Because I think part of the problem from the outset is that Mr. Flanigan is not an attorney. What he knows is he's serving a 6-year sentence 15 years after it was imposed. He's in custody, has no idea why. He files a petition that he calls a post-conviction and a Rule 36.1. He doesn't know all the magic words that he needs to put in there. And so when he gets in front of the trial court, he doesn't know all of these things that he is expected suddenly to say and doesn't have an attorney to help him at this stage. And so I suppose if this case is going to go back to the trial court, as long as Mr. Flanigan is permitted to have an attorney to help him kind of articulate the issues that he has with his sentence, then I think we're okay with that. Because I do think once we actually do get into the calculations rather than the state's kind of just reading of TDOC's printouts, that we will find that his sentence has in fact expired, that the trial court's original calculations are correct. And so if the court wants to send it back so that we can just confirm that, then we're more than okay with going back and doing that.
What do we do with the writ in the meantime?
That is a tougher question that I do not know the answer to. I've looked because, frankly, I'm not sure it's happened, or at least hasn't happened in an appellate case where a writ has been granted and this court is kind of figuring out what to do with it.
Well, leave it to us to happen upon it. I said leave it to us to happen upon this situation, potentially. So what do we do? I mean, I'd granted the order, I believe, denying the state's request for a stay. So the writ's effective, he's out. How do we send the case back down without reversing the writ? What do we do there?
Okay, if the court were going to send it back for the trial court's consideration, I'm sorry, I'm just thinking this out loud right now with the court, because I do not know exactly procedurally how the court would do that. I think it might just be the benefit of 104's kind of the breadth of it could just be we send it back to the court with instructions to consider whether 104 was an adequate basis to grant relief for the reasons that were in the original order. That might be a reason, or that might be a way to send it back if the court is inclined to do that. I would, again, turn back ultimately, though, to my waiver point. I know the court has feelings about what the Attorney General's role in the habeas court is, but the state of Tennessee is represented in criminal matters all of the time by district attorneys. The district attorney's office was there. The trial judge, all it had in front of it was a pleading that said, Maurice Flanigan v. State of Tennessee. In front of him, he had Maurice Flanigan, and he had an attorney who says, I represent the state of Tennessee. Under those circumstances, a trial judge should be able to take it at face value that the attorney representing the state has the authority to do so and grant relief accordingly.
Mr. Ridley, thank you very much.
Thanks.
Thank you. General, you have 5 minutes of rebuttal.
Thank you, Your Honor. I'll be brief. Just to address the waiver argument that we've been discussing. Repeatedly, my friend on the other side referred to habeas, or this proceeding, as a criminal case or a criminal matter. But the problem is habeas corpus proceedings are civil in nature. And that is from State ex rel. Folds versus Hunt, decided by the Tennessee Supreme Court in 1965. It's cited on page 5 of my reply brief. And there's no statutory authority for the DAs to represent the state in civil matters, and that was affirmed again in Effler versus Purdue Pharma just a few years ago. Instead, it is the Attorney General's office who represents the state, or here, although we often see habeas corpus petitions styled as the defendant versus the state of Tennessee, it's actually the defendant versus the warden or the authority holding them.
Are you aware of authority other than PERTL, which would recognize the authority of the Attorney General, maybe perhaps exclusively to represent the state in a habeas case?
I do not, PERTL is the case cited in my brief. I'm happy to provide supplemental authority if this
No, that's
court
okay.
likes.
Yeah.
But I think Folds versus Hunt and the Tennessee Code annotated 86109, which is the statutory authority for this AG's office to represent the state in civil matters, conclusively shows that habeas corpus proceedings are civil in nature and therefore are represented exclusively by the state attorney general's office and not the district attorneys.
So to take Mr. Ridley's point, I mean, the DA had zero authority to represent the state in this case. I agree with that. But from Mr. Flanigan's perspective, he doesn't know the contours of the statutory authority of the AG versus the DAG. We're arguing about it here. Why couldn't they pick up the phone in Chattanooga and call Nashville?
Oh, easy now.
I think that is,
We have phones in Chattanooga, that's right.
and I do not mean to be cagey, I think my answer depends on which party is calling the AG's office. Certainly and I do want to reiterate that this was initially styled as a Rule 36.1 motion, in which the AG is the DA's office is the proper respondent. But because the court construed it as a habeas corpus petition and granted relief before the DA was consulted, I do feel like that is important. The writ had gone down before the DA's office was consulted in this case. That makes this very complicated. And often the DAs do, were this styled as a habeas corpus petition, yes, they call the AG's office. The best practice is for them to call us and get involved. Now, with this case specifically, it probably would have been best practice for the court to say, hey, parties, before I issue this order, I think this is a habeas petition. Let's get the right parties here. Call the AG's office. That's not what happened here.
I mean, they could have though, right? I mean, there was about a 3-week gap between the court's issuing of the order and the hearing that followed, right?
They could have, but the substantive order was already issued.
Sure.
And that's the findings. So.
But had the AG's office been notified, the AG could have appeared and said, we object, and we ask you to reconsider. You don't have authority to do this, right?
They could have, but.
And so then we wouldn't be talking about whether you had waived arguments on appeal by waiving them in the trial court, because the right party would have been able to be there to make the objections.
Yes, Your Honor, that is correct. But I still would submit, though, that that does not mean the state has waived these arguments here, because the waiver argument is based on the incorrect state's attorney making assertions to the court, and a waiver cannot be based on an incorrect party's statements. Just to answer you, or briefly address the questions of what do we do with the writ? If this court were to remand for the AG's office to be a party, I think the only option here is to reverse the writ. I think even if this court is to order a remand, there's still, the proper parties have not been heard. There is not clear evidence in the record that this sentence has expired. And if we are remanding for further consideration, then the proper procedure is to put the parties back in the position as if the defendant has simply filed this petition, and we start from there. And to do that, you have to reverse the writ of habeas corpus. So unless there are any further questions, we ask that you reverse the judgment of the habeas corpus court, and I thank your honors for your time.
General, thank you.
Thank you all.
Ms. Ridley, thank you very much. I appreciate you all being here, particularly at this time of year. I appreciate your travel and accommodating the court. Excellent argument. Thank you all. With that, Mr. Clerk, I believe that we have concluded our business and we shall stand adjourned.
All right.